in this class we would do a introduction to the law of torts. Another very important part of our legal reasoning chapters which are included in our CLAT exam is the law of torts. Now you would want to know what is exactly law of tort. You must have never heard the word tort. So I would tell you where this word has been derived from. It is basically a Latin word which means tortum, which means a twisted conduct, something which is not done properly, something in simple terms, in an English word I would say that something that is wrong, something that is not done in its proper nature, the way it was supposedly to be done. So basically a tort is a conduct that is not proper and is crooked and twisted. So something which is not straight but a little crooked or twisted. The remedy for tort lies in the civil law. Now, if any kind of tort has taken place, where do I go? I go to the civil court. I cannot approach the criminal court because it is not a crime. It is a civil wrong which is done from one person to another person, and so I would approach to the civil law. Torts in everyday life. Tort can be defined as a civil wrong arising when one individual breaches a legal duty which he owes to another individual. All the individuals owe, each individual owes a legal duty to the other individual. So, tort can be defined as a civil wrong where one person is liable to another person to perform a legal duty, but he is not doing it, and so it will arise to a tort. Claims in tort law are awarded unliquidated damages and are separate from claims in contract law. So what happens when a tort law is taken place? I go to the civil court, and what will the civil court do? How will I be satisfied? What damages would be given to me, and how will they be uncertain? So the damages which we deal in tort law are unliquidated damages. Now again, you would want to know what is unliquidated damages. So unliquidated damages are monetary compensation which are not predetermined. Alright, when I get into in simple terms, when I get into a contract or an agreement, I say if you have to paint my house within 15 days. If you do not do so, then I will deduct 5,000 rupees from your the money I have to, the lump sum money which I have to pay to you. If you take more than 15 days, I will deduct 5,000 rupees from your actual money which I have to pay to you. So what is this damage? This is a liquidated damage because it is pre-decided. It is previously ascertained that if a wrong is done, 5,000 rupees would be deducted. But what happens in case of unliquidated damages? Nobody knows what wrong will take place and when will the wrong take place, and so the damage is not predetermined by the parties but are decided by the judge in the court of law. And then whom do we approach? We go to the court, we go to the civil court. The judge will take the scenario of the whole situation, will ascertain what kind of a wrong has taken place, and in knowing these facts, the judge would be able to decide what compensation or what damages have to be awarded. So they are unliquidated damages because no amount of money is fixed in these damages. Let's quickly look at an example. If you go to your neighbor's house, you are expected to ring the bell, take his or her permission before you enter his house. This is normal thing, everybody follows. You cannot go straight into his kitchen and start doing whatever you like. You cannot straight bang into his kitchen, open his fridge and start eating his vanilla ice cream. Is this how we need to behave in a civilized society? No. You take his permission before you help yourself with the ice cream in the fridge. If you do not do this, then what happens? You have behaved in a manner which is unacceptable and you have breached your duty towards your neighbor and you have committed a tort. It is your legal duty. It is a legal duty between two people. It is your legal duty that you need to take the permission of your neighbor before you set a foot inside his house, before inside his land, inside his in his place. Okay, so this is actually a very simple example of tort which I could give to you, and as we move further, I would give you more examples which will make you even easier to understand the day-to-day torts which take place in our lives. Now there are some important points which I will just tell you. First is, a tort is a private wrong. It is not a wrong against the society. Okay, because one person owes a legal duty towards the other person. So it is between two people. It is a private wrong. When we say a crime has been committed, a crime is against the whole society. So we say a crime against a person is a crime against the society. But a tort always takes place between two people. So it is a private wrong. Second is, remedy for tort lies in civil law and not in criminal law. So if we have a issue, I have a case pertaining to torts, I would approach to the civil court and I would not rather go to the criminal court. Third, it involves violation of a legal duty. I have told you that everybody living in a society owes legal duty towards each other, and if you do not stick to your legal duty, if you try to violate your legal duty, you have committed a tort. Fourth, it leads to a liability on the part of the wrongdoer. The one who has done the wrong will bear the liability. Fifth, the compensation awarded is unliquidated in nature. As I have already told you that the kind of damages which are awarded are unliquidated. They are not decided previously. Okay, so these are some of the important points which we need to keep in mind when we deal with law of torts. Now, what is the position of the law of torts in India? In India, tort law as it exists today is derived from common law principles and English law specifically. Now, tort law basically has no particular one act in India. It is derived basically from the English law. We in India are relied on the laws framed by England to deal with the torts. Over the last century, the Indian law combined with the English law to form our tort law principles. The law of tort is based on principles. We do not have any particular one act of law of tort which would deal with the torts, because another point of not coming up with one single act would be because torts are innumerable in nature, innumerable legal duties people owe towards each other. It is very difficult to define a set of legal duties. So that is why the law of torts is based on the principles of the legal duties which people owe towards each other, and if they are not able to perform those legal duties, they will be liable for tort, and the punishment and the damages would be decided by the judges there and then. Tort law is unwritten in our country because it is dependent on specific situation and there is no one size that fits all. So there would be no one situation that would fit to every circumstance. So there has to be different situations, and different situations have to be dealt in different ways. Some principles are codified. Now, some principles relating to specific set of people have been tried to codify. Two such examples I would give you is Consumer Protection Act 1986, which deals with the relationship between the sellers and the consumers, and how they are, if there are any kind of defects, how they have to deal with the products, and it involves the consumer who is buying the things to protect the consumer. Motor Vehicles Act, again, one of the if a wrong takes place, if you are over speeding, if you're not wearing a helmet, if you're not wearing your seat belt, so what would be the damages that would be incurred to you are mentioned in the Motor Vehicles Act 1988. Tort cases are not very high in India because most people are unaware of their rights to sue under tort law. Also, the standard of compensation is not very high and the court proceedings take a lot of time. One major issue in India that people for very small issues they avoid going to the court because they feel that the compensation would be very less, But the court proceedings in India, as we are all aware, takes a lot of time. So that is why still tort cases are not very popular in nature in India. It is a tedious process, but slowly people are being aware of the presence of this law and their rights under it. But slowly, as the society is developing, the youth is getting aware of their rights, and they are being more aware of the presence of these laws and their rights under it. For example, recently MS Dhoni filed a suit against the Zee News, moving to the Madras High Court seeking damages of rupees 100 crore on the claim of the tort of defamation. So he had put an allegation on the Zee News that they had in MS Dhoni's name they had defamed MS Dhoni. They have published some news which was defaming in nature, which has affected his reputation, and so he was seeking damages of rupees 100 crores. Two important principles to be remembered in torts. First is damnum sine injuria. What is damnum sine injuria? Means damages without injury, where you have incurred damages but there has been no injury. In this case, no compensation will be awarded unless there is a violation of legal rights. Until and unless legal rights have been violated, no compensation will be awarded. There are some landmark cases which I will discuss with you. First is Usha Ben versus Bhagya Lakshmi Chitra Mandir. In this case, the plaintiff sued the defendant of permanent injunction as movie Jai Santoshi Ma was hurting the religious sentiments as the goddess was depicted as jealous. No compensation was given as there was no violation of legal right. Now what in this plaintiff said that I want that there should be a permanent injunction that this movie Jai Santoshi Ma should be banned because it is hurting the religious emotions and sentiments of the people. Why? Because the nature of the goddess is shown to be jealous, is depicted to be jealous. So no, but what the court said? The court said no, there will be no legal compensation given as there is no violation of a legal right. The court stated that there was no need to ban the movie. On the other hand, anyone whose sentiments or emotions were being hurt was very well free to not watch the picture. So there was no violation of legal right and no compensation was granted. Second would be Mogul Steamship Company versus McGregor's Company. All steamship companies united and drove the plaintiff's company out of the tea trade by reducing their freights, due to which the plaintiff suffered losses. Now this could be a strategy of marketing where the 10-15 companies, how many were there, they just got together and they secluded one company and they reduced their freights so that nobody would go to his company, and due to which the plaintiff had suffered losses. No compensation was awarded as other company was only doing their marketing practices and there wasn't any injury to the plaintiff. There was no major injury to the plaintiff. Why? Because other companies were just using a marketing strategy or marketing practice to boost their business. Second point, element which we talk about is injuria sine damnum, means injury without damage. It is an infringement of a private right without any loss. Now here your right has been infringed but no loss or damage has been caused to you. Therefore, plaintiff will be compensated if his legal rights are violated, even though there is no actual loss. The law of tort says that you do not have to breach the legal duty of any individual which you owe towards the other person. If you breach the legal duty, you will have to suffer the damage or you will have to suffer the loss. The case I would discuss with you is Bhim Singh versus State of Jammu and Kashmir. In this case, the petitioner, who was an MLA of Jammu and Kashmir Assembly, who was wrongfully detained by the police when he was going to attend the assembly session. Now, Bhim Singh, this MLA, was going to attend his assembly session, but by mistake the police detained him. He was not produced before the magistrate before the reasonable time, and as a consequence of this the member was deprived of his constitutional rights. He asked the police that he should be presented before the magistrate because he was wrongfully detained, but it was not done in time, and therefore he could not exercise his rights or the duty which he had to do in the assembly, and he said that my constitutional rights have been infringed. There was violation of fundamental rights to personal liberty guaranteed under Article 21 of the Constitution. Our Constitution tells us that every person has to live a life full of liberty. So you cannot wrongfully detain any person, and even if you have detained him within a reasonable time, you have to present him before the magistrate. So in this case, the court ordered to pay damages of rupees 50,000 to the petitioner because his constitutional rights and his legal right were infringed by the police officer. Second case would be Ashby versus White. Plaintiff was confined by the returning officer, due to which plaintiff was not able to cast the vote, though the party in the election won the election. Now this Ashby, he was going to cast a vote in the elections for a particular party, and the returning officer refused that no, you cannot cast the vote. He did not let him cast the vote, though the party for which he wanted to vote won the election. Still he wanted the damages. He said, no, my legal right, my constitutional right to cast a vote has been infringed. It has been violated. There was a violation of legal right of a person. So here the compensation was granted.